former Commissioner, Body Corporate Community Management, Consultant, Hines Legal, and with me, as always, Frank Higginson, Partner, Hines Legal. Frank, welcome.
Hello, Chris. Hello, everyone. Yet again.
Thanks, everyone, for joining us. We do really appreciate the fact that you make the effort to tune in. And this week, we reckon we've got a pretty good topic, discrimination in strata. We'll get to that in just a second. As always, if you have a question, and particularly if it's a detailed one, please ask us that via the form. We're putting up the link to that. It should appear in chat in just a moment. Also, don't forget that we're approaching the end of September. Geez, that was quick. And so we will be having the October webinar topics out to you all shortly. So please make sure to subscribe to get notified of that. But discrimination, Frank, it's a pretty intense area, this one, isn't it?
It is. It's very emotional. It's very easy to use the word. It's usually a lot harder to prove it. And today, I suppose we're delving into some areas in which we're not necessarily what you'd call experts in terms of actually anti-discrimination law in the sense of the Anti-Discrimination Act. But there is a bit of strata intersection there. So I think today, talk about anti-discrimination as a whole, certainly discrimination in relation to strata, but I think the caveat that we need to put on this is that we're not what we'd call experts in this area. So we're going to go through some general stuff, but I mean, the more, and I have dealt with a bit of this over the years, the more you deal with it, the more so, and made even more so maybe than body corporate, every single set of circumstances and facts is different. When it comes to discrimination, there's a lot more moving parts and the legislation's a fair bit more technical. So this is definitely one not to go off half-cocked at. And we have a couple of war stories for that later on. So,
absolutely.
It's an interesting one.
And it's something that's it's quite topical at the moment because we're hearing the word discrimination used a lot in relation to COVID and in relation to vaccines. And we're going to actually delve into that a bit later in the webinar. COVID, vaccines, discrimination, strata. Stay tuned for that one.
Spitballing.
Yeah, absolutely. Some things that body corporate needs to consider. Let's just quickly talk about the word, I suppose, Frank. It has a literal meaning and it has a legislative meaning, doesn't it? So let's remember the literal meaning of discrimination is where effectively you make a judgment call between two or more things. It used to be used a lot in the context, didn't it, of describing someone. That person has discriminating tastes. So that tended to mean that they liked the finer things in life, for argument's sake. They were choosing to prefer those things over some other things. Discrimination in the legislative context is very, very tightly defined and prescribed, and that's kind of what we're going to be talking about a bit more today. Here's a point that we want to kick off with, I suppose, and it's one point that I feel pretty strongly about. I think you do too, Frank. The idea of referring to yourself as being discriminated against when you are not. And I actually think that is really counterproductive to go around saying, I'm being discriminated against when that is not the case. And do you agree, Frank?
I do. And that's one of the, it's an interesting one to do this webinar because we get this a lot. Particularly from lot owner clients who sort of, contact us and saying they're being discriminated against. And I suppose for me, usually that has arisen because they're not happy with something, but why that something has happened is very rarely discrimination.
Yep.
So I think for me, a lot of people, sorry if I'm annoying some people that might be watching, use discrimination as a cover for why they're not getting their way and use it as a blaming tool. And it's not actually that more often than not. That's True right. Discrimination is pretty rare in strata.
It is, Frank. And I think to call yourself being discriminated against when you are not weakens your position. It also puts you in a position where you're casting yourself as a victim. And that can't help in any circumstances. As you well know, Frank, one of my big triggers in life is when people start making random references to Nazis. A number of times I've been at seminars and I've heard committees described as Gestapo. No, they're not. They're a committee. There is a huge, vast difference. More or less the same thing here. because you did not get what you want does not mean you were discriminated against. Let's make that very clear at the start. So let's talk about the legislative meaning of discrimination then. Frank, where does that come from?
The Anti-Discrimination Act, Queensland, 1991. I suppose it's interesting, this, because there's federal discrimination laws and there's state discrimination laws. So as close as I'll get to being a constitutional lawyer is in relation to something like this, because we've got a constitution that says the federal government can deal with X, Y, and Z, and the states get to deal with everything else. So and that's why I suppose you look at property laws. Property laws are not a federal responsibility, which means each state does what it wants. And across the board, you've got that with hospitals, crime, police, all that sort of stuff. So what's not federally reserved is left in the domain of the states. And so what we've got then is sort of two systems, but today we're talking about the state one. And really, that's back to, as Chris was saying before, having discriminating tastes. It's a way to describe someone who is different, which is fine, but from a legislative context, the way it's used, of course, is that you are different and you're being treated differently because of that.
That's right.
That's probably the key thing.
So what does that mean in a bit more detail? Well, I guess the Act actually says that not all treatment that seems unfair is unlawful discrimination, kind of what you were just saying there, Frank. For conduct to be unlawful discrimination, it must be based on an attribute, and we'll list those attributes in a minute. There's a few of them. It must also take place in an area of activity listed in the Act. And then finally, it must result in you being treated less favourably than someone without that attribute. So they're 3 and statements. All 3 must be satisfied. So why don't we take these one by one, Frank? So here are the attributes under which you could potentially be discriminated. Sex, gender.
Yep. Relationship status, married or unmarried.
Pregnancy, self-explanatory.
Yeah, absolutely. Parental status, kids or no kids.
Breastfeeding. Breastfeeding is an attribute to be discriminated against.
And age, of course. I mean, interestingly enough, there's been a recent big blue in one of the accounting firms where they had a compulsory retirement age for partners at 65, where they had to go. And one of the partners who didn't want to go took them on about that. And I don't know how they possibly tried to defend it, because that is so discriminatory, it's not funny.
Definitely. Race, that seems pretty obvious.
Easy.
That one.
Yep. Impairment. So I suppose some sort of disability or otherwise.
Which you'll be touching upon in a little bit, Frank.
Yep.
Religious belief or religious activity.
And same, political belief. Labor, Liberal, Democrat, Pauline Hanson, Liberal Democrat, who knows?
Yep. And very closely related then, I suppose, trade union activity is another one.
Yep. Lawful sexual activity.
Gender identity.
Sexuality.
Family responsibilities.
And then I suppose association with someone with any of those other attributes. So, yeah, I'm married to someone of colour, and I'm getting discriminated against because of that.
Yeah. So they're the attributes. So then, when and where does that become unlawful? And so might do this again, Frank, one by one. Yep. So these are the contexts in which it becomes unlawful. So work. So that includes applying for a job or doing work experience.
Yep, saying no to someone because they're pregnant. Absolutely, DQs you. Education, getting education. And you see that sometimes in the school system in terms of religious schools and otherwise.
Provision of goods and services, superannuation or insurance.
Accommodation, permanent or short-term.
Pretty relevant for our purposes. Disposition of land. So that's also kind of relevant here.
Yeah. Club memberships and club affairs. I suppose, like I'm a member at Royal Queensland Golf Club, and we had a discrimination case in relation to ladies and male members a couple of years ago. So very familiar with that.
Okay. Administration of state laws and programs.
So what's that? Making sure that government funding's fairly distributed?
Yeah, pretty much. I think that's a really good example, actually, Frank.
Yep. And local government between members.
So,
interesting.
the interesting thing that emerges out of that list, that there's nothing on there whatsoever that talks about discrimination on the basis of whether you are a lot owner, whether you are an occupier, or whether you are any other part of the body corporate. You can maybe interpret it one of those particular ways, but there's no explicit mention to your role in the body corporate. That said, though, Frank, I know that the Queensland Human Rights Commission does consider complaints that are kind of in the field of a body of nature of a body corporate, and they're very much like my former office in that they try and conciliate complaints. So they try and bring the parties together and get them to agree on something they can all live with thereafter, and then there is a formal process afterwards, not adjudication like there is for body corporate commissioner, but there is a formal process which follows. And then separately, we've got human rights, don't we, Frank?
We do, and that's primarily related to government activities, isn't it?
Yeah.
Provision of government services. So no, I actually read that legislation when it came out, but it's sort of at the time it was applying, not to us in private land, but making sure the government does what it should do in relation to, I suppose, equality of services and offerings and treatment of people, isn't it?
And so there are 23 legislated human rights. We're not going to go over the 23 just now, but we're putting up the link to that legislation so you can take a look at those for yourself. So,
probably, I was going to say, just in terms of the Human Rights Commission, I know one of my very early dealings with that in a body corporate context was a chairperson who had a complaint lodged against him in the Human Rights Commission by a mother of 2 children when, and again, always facts, different opinions, that sort of thing. Kids are out running around allegedly at 9 o'clock at night. Chairperson goes and knocks on mum's door and says, if you don't mind trying to rein them in a little bit, it's noisy, people are trying to sleep, etc., etc. That produced a complaint to the Human Rights Commission about discrimination based on parental responsibilities.
Right.
And it was relating to accommodation. So they're not that hard to file, is my experience, those type of complaints. At least in the Commissioner's office, there's a jurisdictional element to it to start with.
Yeah.
You've got to try your self-resolution to start with, and then there's case managers and all those sort of things. This thing sort of appeared overnight.
Yeah, that's right. Yes, very, very different process. So what does it all mean? If your body corporate is treating you in a way you don't like, it's not going to be discrimination for the purposes of the Anti-Discrimination Act, we think.
Unless it fits some of those things, which is going to be relatively rare.
Yeah. So where does discrimination fit in a strata sense, Frank?
Well, and this is the really interesting thing. I suppose when you look at the BCCM Act, if you're going to do a word search of that for discrimination, you're going to find it in section 180 brackets 5. And that is the section, as we talk about all the time, probably the 8 rules of bylaws, what you can't do. And that's one that prohibits a bylaw from discriminating between a type of occupier. So a bylaw can't say that owners can use the pool till 9 o'clock at night, but tenants must be out by 6 p.m. as a simple example. Can't do that. Yeah. Everyone's occupiers, everyone's got the same rights. And that is really where body corporate legislation starts and finishes with respect to the use of the word discrimination.
Yep.
That's it. So where, and I suppose we might move on and talk about 19th Avenue. So Chris will put up a link to this decision, which is actually really, really lengthy. So this is a case where an owner-occupier in a unit suffered the loss of bodily function, which meant that she was in a wheelchair. So she couldn't access certain parts of common property. So this process started for her in 2013 and concluded in 2020. So it's relatively long and drawn out. And if you've got the time and you want to read the decision, it's quite interesting in terms of some of the touchy-feely elements of this, because you can read the decision and some of the delay wasn't necessarily the body corporates. It was definitely the occupiers in terms of progressing what they had to do and all that sort of stuff. But it's a really interesting thing where effectively there were 5 things that were complained of throughout. 4 of them got dealt with along the way. So access to Foyers, couldn't access the pool area because the way to access the pool area was swiping a fob and pulling the door towards you, which is really hard when you're in a wheelchair. So there's other, obviously, mechanical ways to fix that, which the body corporate did. But where this decision, I think, is really important for bodies corporate and everyone in strata is that the occupier couldn't use the pool because they couldn't get into the pool because there wasn't the means available to do so. So part of this decision had an expert's report prepared for the body corporate before there was a dispute about the ways that the accessibility issues could have been addressed. And there's a range of different ways about a range of different things. So the body corporate's dealt with 4 of them, and for whatever reason decided to go with the pool hoist option. So I think you put yourself in the hoist and can swing around and get in the pool that way when you're less mobile. And the body corporate put all of these motions up to general meeting, and the pool hoist motion was defeated. So owners voted that down. And that was really the crux of this decision, where the judge, it was QCAT member, I suppose. We've got members, adjudicators, judges. The member of QCAT who heard the proceeding decided that that wasn't a reasonable decision for the body corporate under an anti-discrimination sense. And for me, one of the telling comments in there was the pool hoist was $8,000, including GST. The body corporate had $1 million in its bank account. It had spent $665,000 in the preceding 12 months. And yet, for some reason, it's declined to spend $8,000 to solve the mobility issue for this particular owner in circumstances where it quite clearly was needed, and they'd warned the other 4. So I don't know why or how or whatever that came about, but where it got to is the member, I think in a relative sense, was quite scathing about that decision. And it's really interesting in the context that because what members of the judiciary have the ability to do is to make orders then based on whatever they think should happen. And in this one, the member specifically declined to make an order that the hoist be installed because there were other ways for the body corporate to address the issues that were in the expert's report, but they have ordered that the body corporate deal with it. So the body corporate must address this issue in the way that it chooses. Doesn't necessarily need to be this way, but it can't leave it sit. And then also fined the body corporate $5,000 and made the body corporate issue a private apology to the owner or the occupier for that process. So I suppose, what came out to me loud and clear on this, and we've had a little bit to do with this building over the years, it didn't act in this particular matter, I know some of the people involved, is they're all volunteers. They're all caught up in a legal quagmire, and they're dragged through this process, and who knows how many hours of their lives they've lost and stress it's caused them for the sake of doing something for $8,000 in circumstances where it's relatively lay down misere. And even interestingly, when we were Googling around getting some of this before we did it, we found a letter from the Federal Human Rights Commissioner. Was it Chris from 2008?
Yeah.
That Chris will put up there that talks about body corporate responsibilities in relation to the Federal Discrimination Act and whether a body corporate could be responsible for making changes or be required to making changes to common property as a result of someone being less mobile. And the conclusion in that letter was absolutely the case, and that proved to be 100% true in a state sense when it got to QCAT. Yeah. So I suppose from a body corporate perspective, just because something's been built in a certain way doesn't mean that the body corporate might not be required to change it to address the needs of someone in the building who could otherwise be considered to be discriminated against.
Yep.
If you're going to have one golden rule, that's it.
Yep.
So, just be ready. That's just the reality of it. And I suppose probably don't necessarily take the ostrich approach and hope it goes away. So that's discrimination under the Anti-Discrimination Act. So that wasn't a BCCM thing. That was an Anti-Discrimination Act thing. So from a BCCM perspective, and I suppose, Chris, I've been on my little soapbox for a while now. I might throw back to you.
Yeah.
And you would have had a heap of this. I mean, I know there was there was a webinar. What was it? Barned, bullying,
abuse,
harassment,
discrimination. Yeah.
Yeah. There was a series that might have started in your regime as commissioner.
Yeah.
Road shows, because obviously there's a lot of it that came into your office.
Yeah, it did. And so if someone is feeling as though they're discriminated against in the body corporate, the chances are we actually think that some of these things are probably happening. So first of all, bylaws are being inconsistently applied, or they're not being enforced at all. That's probably the most likely, I would suggest. Self-interest is ruling the day, particularly when it comes to committee decisions. So there's probably a problem in that regard. Approval requests are either not being decided upon in a timely way, or they're not being decided at all. That should now be addressed with the changes in the legislation, but that is absolutely a way someone can feel discriminated against. Unreasonable decisions being made, and that can include excessive or unreasonable decisions. They don't get what they want. The issue is why. Discrimination, easy to say, harder to prove. There's some of the contextual issues around feeling discrimination, but on the flip side of that, a feeling of discrimination might come about because the committee is actually doing its job. And so if the committee is enforcing bylaws, for example, or it's taking the time it needs to make an informed decision, and particularly if that has not happened before, or it's a new committee and it's been a while since things were done that, or a new body corporate manager for that matter, who is instilling a bit more rigor into the process, as they should, it's very easy to think that you could be being discriminated against that way. You've got a bit of a war story there, Frank?
Oh, yeah, that's the North Queensland one I was mentioning before with knocking on the door.
Yeah.
And I suppose, you know, one of the things we get all the time with Strata is it's always been done that way, and then a new broom comes in. So that new broom, new committee, new owners, new Strata manager, new resident manager, people have different ways to approach almost everything. And when that new broom arrives, just because something's been done incorrectly in the past doesn't mean that it should continue to be done that way. So if the committee has consistently ignored bylaws for a period of time, that doesn't remove the statutory obligation to actually enforce bylaws. So suddenly if the new broom is, well, we're going to do the job we're required to do, obviously how that's handled is not necessarily maybe like Genghis Khan, you know, the hordes on the steps, the tundra, all that sort of stuff, but that actually causes grief.
Yep, it does. Speaking of things which cause grief, how about just a bit of discussion about COVID, vaccinations, discrimination and strata? It's a topic that gets bandied about a lot at the moment. It even compels people to go and protest in the streets. Let's throw out a few possibilities here. Frank.
Thinking out loud. This is not legal advice.
No. Do we think a body corporate can resolve to require proof of vaccines, like for things like contractors entering onto common property, or even for someone to occupy?
I reckon with the lead that all of the governments are taking on this in terms of vaccine passports, you know, certainly, leaving aside border crossing, I mean, I don't think there's any actual legislation like this yet. And to be honest, sometimes with COVID, I just shut my ears and don't want to hear any more about it. I just live my own little world at home. But all of the stuff you see would seem to indicate that the government is going to endorse an approach of people being able to make choices about who attends their establishments based on whether or not they're vaccinated. And so if bodies corporate are going to be able to follow that lead, to me, it probably does say that. And I suppose then you've almost got to look at the contractors. So say we're engaged to do a gig for a body corporate. We're going to go and meet the committee on site. It's open for the committee to say to us as a contractor, Frank, we're only going to allow you to come on site and meet with us if you're vaccinated. And if that's the stage, there we go. It might be slightly different in a body corporate management context or even a management rights context where there's a contract for service, with Irons Management Proprietary Limited, who has 15 staff, some of which might be vaccinated and some of which might not be. And the contract for service you've got says that you're going to go to 4 committee meetings a year on site, and there's no special condition in there saying from the body corporate side of things that your staff who attend must be vaccinated. Now, I suppose as a business owner, you might make the decision, well, I'm going to only send vaccinated staff. So you ring the chairperson, Frank's not vaccinated, he's an anti-vaxxer, I'm not. But so we won't send him, which means your body corporate manager from this point forward is Tony. And that might be the way to deal with that. But it's interesting. That's coming. Haven't seen it yet, but that's coming.
We think so. What about the idea that the body corporate might be able to resolve that your attendance at a general meeting or a committee meeting could only be on the basis that you're fully vaccinated?
Probably a little bit tighter in the sense of contractors don't necessarily have an entitlement to do the things they're doing in terms of being on site. Lot owners, committee members certainly do have an entitlement to participate in the affairs of the body corporate in which they own a lot, or they're a representative of someone for. So I think, I'll go out on a limb here, if a body corporate provided, I think this is probably a legislative thing at some stage, we've got our COVID regulations still lurking around. If a body corporate provided a guaranteed certain means for people to attend electronically and then said, you can't come unless you're vaccinated, we're probably getting closer to it.
Yeah,
we're probably getting closer to it. That is a really, really interesting one from a strata perspective. But if you didn't have the means to attend electronically and then the resolution was made, you can't come unless you're vaccinated, so there was no other way to participate in the meeting, I think that's getting a little bit harder.
Okay. And then the last one, what about the idea of the body corporate resolving that the use of the common property by occupiers can only be on the basis that they're vaccinated?
Crikey. And I suppose it's interesting. We're talking about discrimination before. Yep. Sorry to point, just thinking. Yep. This is my thinking mode. We're talking about discrimination before. So discrimination, a body corporate bylaw. So it's a restricted issue to start with. We know that because that got litigated in COVID. Committees can't make decisions to shut off common property. They can now when they're doing it pursuant to a health direction. Yep. But that's to everyone. That's not to a certain class of person. So when we're talking about 185, that talks about prohibiting bylaws from discriminating between the types of occupiers. So to me, that is owners, tenants.
Right, but
I don't think it's necessarily saying you can't discriminate about the characteristics of occupiers. And so when you go back up to where we started, I suppose, anti-discrimination legislation, so that legislation is going to prevent you from saying, okay, you can't use the gym if you're a Catholic because that's discrimination based on religion. There's nothing there in the discrimination section there that talks about vaccination status yet.
That's right.
Yeah. So maybe. And again, you follow the government's lead in terms of what they're saying about policy and what they're saying they're going to allow people to do. It naturally follows that people are going to be able to make decisions, except of course the body corporate thing is always coloured by, again, my workplace. I can say to you potentially, Chris, if you're a client, you're not vaccinated, I don't want to see you in here and therefore I don't act for you, and that's fine. You don't pay me any money, we're done. But if I'm a lot owner or a tenant and I'm paying a cost to participate, rent, body corporate levies, and you're telling me no, it's a slightly different legal nuance.
It certainly is. That's a tough one, that one. But I'm certain that one will come up in the not too distant future, if it hasn't already.
Yeah.
I'm certain it will. In the short time we've got left, our takeaways for today, Em. So reiterate the point we made at the start. Please don't go around suggesting that you are being discriminated against if you really are not. There is a world of difference between not getting something that you wanted as opposed to actual discrimination under the legislation. I guess point two, if you are truly being discriminated against, then you need to do something about it. It's unlikely to the point of impossible that someone's going to do that for you. The onus is upon you to enforce your rights. And there are ways and means to do it, and there's assistance and resources available to you. And then finally, if discrimination is a consequence of incorrect or inconsistent bylaw enforcement, which I reckon, Frank, happens in a lot of cases, then the takeaway there, follow the correct process, or make sure your body corporate follows the correct process. And The correct process and the absolute best resource that you will have for that, short of legal advice, is the Commissioner's Office flowchart about bylaw enforcement, which we've just put up a link to there. Time and again, we refer to this one. It really is the thing.
Just tick the box.
Yeah.
Just tick the boxes.
If A, then B. Yeah.
Yep.
Pretty simple.
Yep.
We've come to the end, Frank. Thank you.
Going out on a limb, talking about areas which I don't do every day. It's good. It's good to keep you thinking.
Yeah, it's agile stuff. Next week, we're getting all exclusive. We're talking exclusive use, but there's more than one type of exclusivity.
Well, rights to use common property, isn't it?
Yeah, rights to use.
To the exclusion of others. Yeah. Which is exclusive use is one way. There are multiple others.
That's right. So next week we're talking about using common property. But for now, Frank, thank you.
Thanks, mate. Welcome indeed.
Thank you. Thanks everyone for tuning in. We really do appreciate it. We'll see you next week.
Done. Bye, everyone.
Bye.